Hello, everyone, and welcome to today's Fair Work Ombudsman's webinar, Workplace Essentials for Migrant Workers and Visa Holders. My name is Jen, and I'll be presenting today's webinar. Today's session is about giving you the essential information you need to know about your workplace rights, including what to look out for and where to get help if things go wrong. Many of you may already be working or planning to work in Australia, so it's important to know what your workplace rights are. Now, don't worry about taking notes on website addresses or any tools or resources mentioned in the webinar. For those who have registered, you'll receive an email after the session with all the links to the information we covered today. And if you're watching on YouTube, you'll be able to access the links in the description below. Just some housekeeping rules. We won't be directly answering questions in the presentation today, but we do have a couple of helpers in our Q&A section of the webinar. So if you have any questions, they'll be able to point you in the right direction if that's applicable. So please feel free to pop questions in the Q&A. It should look like an envelope with a question mark. If you do have workplace issues or would like assistance with resolving a workplace matter, this webinar will not be your best point of contact, as the information in this presentation is only general in nature, and how it applies to you will depend on your personal situation. So for more information and assistance with workplace matters, I do encourage you to visit our website at www.fairwork.gov.au or call us on 13 13 94. Now, before we get into the main presentation, in the spirit of reconciliation, I'd like to acknowledge the traditional custodians of country throughout Australia and their continuing connection to land, waters, skies, and communities. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Today, I'm presenting from Darug country. Okay, let's begin our journey into your workplace rights and entitlements. So I'll start with a little introduction to the Fair Work Ombudsman, or FO as we like to call ourselves, what we do and how we can help. Hopefully most of you have at least heard of us, but if not, that's okay. Today you'll learn a little bit more about what we do. So in Australia, all employees have rights protected by workplace laws. These laws apply to everyone, including migrants and visa holders, regardless of your visa type or your length of stay. The Fair Work Ombudsman, or FO, is Australia's independent national workplace regulator. We provide free, impartial advice, education, and support to employees and employers and organisations. We help resolve workplace issues and offer tailored tools and resources for all workers. It's important to remember we are a separate organisation to the Fair Work Commission, who is Australia's workplace tribunal. They handle issues like unfair dismissal, bullying, sexual harassment, and disputes about awards and agreements. For more information about the Commission and what they do, you can visit their website at www.fwc.gov.au. Now, for those who are international students or visa workers, you may also need to know about the Department of Home Affairs. They handle immigration, visa, and citizenship matters. So if you have questions about visa types, information on changing or cancelling visas and applying for permanent residency, you need to contact the Department of Home Affairs, and you can do that by visiting their website at www.homeaffairs.gov.au. Okay, so you're starting a new job. What do you need to know? They say the best protection against workplace issues is knowledge of your rights. So the first thing you'll want to understand is what your minimum entitlements are. When you first start any job, Your new employer is required to provide you with a copy of the Fair Work Information Statement. This contains really useful information, including the National Employment Standards, or NES, which provides all workers in Australia with a safety net on minimum entitlements. The NES covers things like annual leave, also known as holiday pay, sick and carers leave, also known as personal leave, paid family and domestic violence leave, maximum hours of work, and public holidays. We'll have a look at the Fair Work Information Statement a bit more closely shortly, and if you've started work and you haven't been provided one yet, I'll show you where you can access the document. Now, when you start work, there are two important things to clarify with your employer. The first is whether you're going to be a full-time, part-time, or casual employee. Now, we find a lot of issues, particularly with part-time and casual, as they are similar, but they have very different conditions. And I'll talk a bit more about that shortly. The second thing that's important to clarify upfront is which award or enterprise agreement you'll be covered by, because this will determine what your entitlements are. So what's an award? An award, put simply, is like a rule book of conditions, and it can cover you based on your industry or occupation. There are over 100 modern awards, and they apply to most workers in Australia. Awards provide entitlements such as minimum pay rates for the type of work you're performing. They provide penalty rates, you know, because you can receive a high rate if you work weekends, evenings, or public holidays. They provide information on when breaks can be taken. They also provide information on when overtime applies and what the overtime rates are, and if there are any allowances applicable. Entitlements set out in the award apply automatically, even if you don't sign a contract. If your job fits within an award, those entitlements will apply. An agreement, on the other hand, is like a rule book created just for your workplace. If your workplace has an enterprise agreement, it will apply instead of the relevant award. Now, an agreement is usually negotiated between the employer and the employees, and sometimes with the unions. It's approved by the Fair Work Commission to ensure it's legal and fair. Once you know whether you are full-time, part-time, or casual, and you know which award or agreement covers you, you can then find out what your minimum entitlements are, including what your minimum rate of pay is. And we'll also look at minimum rates of pay a little bit later on. But what about paperwork? What do you need to receive? You should receive payslips. Now, payslips are mandatory and must be provided to you by no later than 1 day after payday. This can be provided to you online, for example, through an intranet portal or via email, or it can be provided to you in hard copy. Regardless of how they're provided to you, they need to contain the same information. So why are payslips important? They're important because they are the evidence of how many hours you've worked and how much you've been paid for the hours you've done. They can also help you check if you've been paid correctly. And if there are any issues or mistakes, they can be used as proof in any action or investigation that's taken to rectify your issue. What about contracts? Do you need to receive a contract before you start working? Well, contracts are actually not a legal requirement under the Fair Work legislation, but they can be very handy in providing you with some important information ahead of you starting your job. Even a letter of offer can sometimes provide important information about your role. Whether you have a contract or not, the award or agreement conditions will still apply, and a contract cannot make you agree to less than the terms of the award or agreement. Now, we've actually put together a list of important information you want to receive from your employer or know about your employer when starting a new job. Okay, so let's have a look at these things. So firstly, you should know your employer's name, the Australian business number, and the location of the business. This is especially important if you're working away from the normal premises, such as if you're doing contract cleaning work or on-site laboring jobs. Because if anything goes wrong, this information will help the firm to provide you with the information and assistance uh, you need to resolve your workplace issues. So, for example, like if there's an underpayment of wages. Apart from turning up on time and making a good impression, it's also important to know your work schedule or your roster so you know what you're actually being paid for. For example, are you working weekends or evenings? Because as I mentioned already, this may attract penalty rates or even overtime. If you're part-time, you should expect to have regular hours of work and often the same shifts every week. Your award or agreement may actually have rules around how your part-time hours need to be worked. Similarly, knowing your regular duties and responsibilities is also important as it can determine what classification level you are under an award or an agreement, which of course affects your minimum pay rate. You may also be entitled to allowances based on your duties and responsibilities. Now, we've already talked about the importance of pay slips, but it's also important to make sure the money you're receiving matches what's provided in the pay slips. If you're being paid into a bank account, check to make sure the amount listed on the payslip is what's actually going into your account. Some of you might be paid in cash. Let me just say it's not against the law to be paid in cash. However, there is a difference between being paid in cash and receiving cash in hand. If you're paid in cash, it's important to make sure that you're on the books, meaning that your employer is keeping employment records and that they're meeting obligations like tax and superannuations and providing you payslips. If you're not on the books and receiving cash in hand payments, Fair Work protections still apply to you and you can still seek our assistance, but you might not be receiving pay slips and you might not be getting the correct pay, and tax and superannuation might also not be being paid. And of course, as mentioned already, as soon as you start work, if not before, you will need to receive a Fair Work information statement. And if you're casual, a casual employment information statement as well. So let's have a closer look at the Fair Work information statement. So I know it's a little bit small, but on your screen now, you can see the Fair Work information statement, or FWIS, as we also call it. Now, the reason why this document is important is that it ties together a lot of the basic information we've discussed so far, such as the national employment standards, awards and agreements, minimum wage, and other entitlements in a single document. It also includes details on how to seek help if things go wrong. So please make sure you actually read it. I know it can be very easy to throw paperwork away, but this is a very important document. You can also get a copy of the FWIS on our website at www.fairwork.gov.au/FWIS. This is also the best place to get the most up-to-date version because, as you can all appreciate, if there are changes to legislation or minimum wage rates, then this can also affect the document. So I talked a little earlier about the different types of employment, full-time, part-time, casual. Let's now take a closer look at some of the differences. Full-time employees, they usually work 38 hours per week or more and are paid for 4 weeks' worth of wages. Part-time employees, they work regular and systematic hours each week and work fewer hours than full-time employees. And as I mentioned already, awards and agreements may have rules around how part-time employees need to be employed. Now, both full-time and part-time employees get paid annual leave and personal leave. However, part-time leave is pro rata, meaning your leave is in is proportional to the number of hours you actually work. Both full-time and part-time are usually entitled to notice of termination, with the amount depending on the length of service and your age. So, for example, under the National Employment Standards, full-time and part-time employees who've worked more than 1 year but less than 3 years are entitled to at least 2 weeks of notice. I should note that this works both ways. Full-time and part-time employees usually need to give notice when they resign, although this is determined by the award or agreement that covers them. Now, casual employees are a little bit different because a person is a casual employee if at the start of employment there's no firm advance commitment to ongoing work and they receive a casual loading or specific casual pay rate under an award, agreement, or contract. So, for example, someone may be a casual employee if their roster changes weekly to suit the employer's needs, meaning their hours and days can vary. They can refuse or swap shifts, and they're paid a casual loading. Now, while casuals don't get paid leave for holidays or illness, they can still receive paid family and domestic violence leave, the same as part-time and full-time employees. To find out more about family and domestic violence leave, you can visit our website at www.fairwork.gov.au/FDBL. So let's now look at the national minimum wage. So as you may remember, we discussed earlier that minimum pay rates can vary between different types of jobs and that most employees are covered by awards or an enterprise agreement. Employees who are not covered by an award or an agreement receive the national minimum wage, which has recently gone through a review and increased 1 July of this year. For full-time and part-time employees, the national minimum wage is $26.44 per hour. For casual employees, it's $33.05 per hour, inclusive of the 25% casual loading. It is important to note that the minimum wage gets reviewed every year and generally takes effect from 1 July of every year. All right, so speaking of minimum wage, there are, however, times when someone can be paid lawfully below the national minimum wage. As we know, the national minimum wage only applies to employees not covered by an award or an agreement. It's also usually the lowest rate that applies in an award. So when might someone be paid less than the current national minimum wage? Well, there's actually a few instances. First, someone might be paid as a junior employee if they're covered by an award or an agreement that contains junior rates. Junior rates generally apply to people who are under the age of 21, but please check your award or agreement as junior ages may vary. Secondly, apprentices and trainees are usually paid less than the national minimum wage. This is due to them needing to complete paid training as part of their assigned coursework. Third, employees with disability may have completed a formal skills assessment under the supported wage system, which is a special workplace arrangement where employers pay wages to a person with disability based on their productivity assessment. And lastly, some award minimum wages may now be less than national minimum wage. So for example, some awards contain introductory pay rates for new employees in their industry. These rates generally apply for a limited time until an employee progresses to the next level. All right, so now that we've looked at some of the minimum entitlements, let's now look at some of the common issues we often see in the workplace. This might help you better understand what to watch out for when you start working. All right, so one of the common issues that we see is underpayment of wages. This includes not receiving the correct hourly rate, not receiving penalty rates or overtimes, and even receiving a salary that doesn't cover the hours that the employee has actually worked. Another common issue is non-payment for work. Sometimes an employer might ask you to do an unpaid work trial to evaluate you for a job you're applying for. This is used to determine if you're suitable for the job by getting you to demonstrate your skills. Unpaid work trials are only okay if it's for the purpose of demonstrating the skills required for the job. For example, if you're looking at going for a job as a barista, an employer might look to assess your ability to make different types of coffee orders. But in that situation, you must be directly supervised, and the trial can only last as long as necessary for you to demonstrate the required skills. If an employer wants to further assess your suitability after a trial, they can either employ you as a casual employee or put you on a probationary period. Either way, if an employer does this, you must be paid for all hours worked. You also need to be paid the right pay for time spent in any compulsory training, whether that's in person, online, or off-site. You must also be paid for attendance at team meetings or opening or closing the business if your employer requires you to be there. Another common issue we see is not receiving the correct final pay. When your employment comes to an end, you may need to receive a final pay. A final pay is any money owing to you at the end of your employment. What you're entitled to will depend on your individual circumstances and any award or agreement that applies to you, as well as whether you're full-time, part-time, or casual. Another issue we see is unauthorized deductions. Deductions can only be made in very limited circumstances and generally need to be for the benefit of the employee. You also have to agree with any deductions made. Finally, the other issue is being paid in goods and services instead of money. This is also known as payment in kind and it is unlawful. This can include being paid in food, goods, and services instead of your wages. As an employee, you must be paid wages for all work performed. It's also important to note you cannot be forced to spend your own money on in-store purchases like jewelry or clothing as part of your workwear. So now that we know some of the common issues we need to keep an eye out for, let's now have a look at what you can do if there is an issue in the workplace. So if you face any workplace problems or have questions about workplace rights, you can contact us, the FO. We are responsible for ensuring workplace laws are complied with and provide free help and advice to employees and employers. Now, it's understandable that you or someone you're helping may be worried about asking questions, making a fuss, or complaining about what's happening at work. But I can't reinforce this enough because it really is okay to ask for information or for help because it's against the law for an employee to be treated differently, or have their shifts cut, or be sacked because they've asked about pay or other entitlements, or because they've contacted the Fair Work Ombudsman. Now, when someone contacts us, the information and concerns are not shared with the employer unless they want us to. As a first step, we usually recommend attempting resolution with your employer yourself. This can often be a great way to fix any issues. We actually have a free online course on our website called Difficult Conversations in the Workplace. The course takes about 30 minutes. It's a bit like choose your own adventure type thing. But essentially, it just gives you the skills to have difficult conversations with your employer. Now, if self-resolution doesn't work or the situation doesn't make self-resolution a viable option, then you can seek assistance from us. You can raise an issue by calling the Fair Work info line, again on that number of 13 13 94, or via my account where you can submit a written inquiry or request for assistance. We can then assess what assistance we can provide you to help resolve your situation. You can also report any problems anonymously through our anonymous tip-off from our website. Now, while this doesn't guarantee any kind of action, it does help the fora form understandings of where potential hotspots of workplace issues might exist. So that's whether by industry or a geographical area. So if you've got an issue, our website has a section called Workplace Problems. It's a good first port of call and will step you through what to do in different situations. Okay, I've mentioned this already, but really the Fair Work Act applies equally to all workers, including visa holders and migrant workers. You can't get into trouble or have your visa cancelled for contacting us. Employers can't cancel your visa, even if you breach visa conditions. Only the Department of Home Affairs can grant, refuse, or cancel visas. The Australian government has introduced 2 pilot programs to support visa holders facing workplace exploitation. These are Strengthening Reporting Protections Pilot and Workplace Justice Visa Pilot. Both pilots are being administered by Home Affairs. Under the Strengthening Reporting Protections pilot, Home Affairs won't cancel your visa if you breach work-related conditions and you meet certain criteria or certain criterias, including that you provide Home Affairs with a workplace exploitation certificate. Under the Workplace Justice Visa pilot, you may be able to temporarily remain in Australia if you meet a certain criterias, including that you provide Home Affairs with a workplace exploitation certificate. The FO and other accredited organisations can issue workplace exploitation certificates. So if you've experienced workplace exploitation, you can contact us, and after we assess your situation, if we find potential non-compliance with the Fair Work Act, a Fair Work inspector may issue a workplace exploitation certificate stating that you've sought help for a workplace exploitation issue and we're investigating your case. It's important to remember that the workplace exploitation certificate is not a recommendation to Home Affairs to grant a visa or protection from cancellation. To apply to Home Affairs for one of the two pilots, you can visit their website for information on eligibility and how to apply. So our website is really easy to navigate and has lots of free tools and resources to help both employees and employers understand their rights and obligations. www.fairwork.gov.au is our website. You can see an image of that here, but as you can see, the information is categorized into topics representing the life cycle of employment, as well as our 2 most popular inquiry subjects being pay and leave. By clicking on the topic button, you can find information that is relevant to your question. Uh, on our website, you can also subscribe to our newsroom and updates. So if there's a particular award that you might be following, then you can subscribe to updates to that. As you can see from here, it's very small, but there's a menu button at the top right-hand corner, and there you can find help for specific groups and industries. And from there, you can also find links to our guides and fact sheets and templates, a calculator, our online courses, which I've already mentioned, and our library articles. So speaking about specific pages, we actually have a dedicated page for visa workers and migrant workers where you can find useful and practical information, including information about protections for migrant workers, which I briefly discussed already. It also includes information on cashback schemes and paying conditions. You'll also find videos including case studies and the Working in Australia video, which is a good summary of workplace entitlements and how to contact the FO. From that menu button, you can also access our dedicated language help page. This page contains professionally translated information into different languages. It also contains information on the free interpreting and translating service that's available to you. Again, you can find links to our YouTube videos for employers and employers about working in Australia, which many are translated into different languages. Now, our website can also be translated into different languages using the Microsoft Translator. It can also recognize any your browser settings and translate the website automatically into your preferred language. Well, that's all we have time for in this webinar. I hope it has been useful in giving you a baseline understanding of your rights and entitlements as you embark on your working journey here in Australia. If you have any further questions or would like to get in touch with us regarding workplace entitlements, you can do so by visiting the Fair Work Ombudsman website or subscribing to our email updates. Again, you can call us on 13 30 94 or use the translating and interpreting service on 131450. If you haven't already, I do highly encourage you to follow us on our social media channels because we share important information there also. And again, you can register for my account. Now here on the screen, you'll see that I've included the links to our visa, workers and migrants page, as well as our language help page. We also regularly deliver webinars tailored for different industries and audiences, including migrant workers. So please check our dedicated webinar page at www.fairwork.gov.au/webinars for information about upcoming webinars and some of our recorded webinars as well. There'll be a quick survey after the webinar, and we'd appreciate if you could answer a few questions to help us develop our webinar program. Should only take a couple of minutes to complete, and we really value your feedback. Thank you again for joining us, and I hope to see you at another webinar in the future.